Hello everyone, Kid here, back with the video. Today for you guys, we're going to be reading the Civil Rights Act of 1968. I'll leave a link to this down in the description below along for email. Email us at themills@gmail.com for information. Without further ado, let's get right into it. Civil Rights Act of 1968, as amended through PL 113-4, enacted March 7, 2013. An act to prescribe penalties for certain acts of violence or intimidation and for other purposes. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that this act may be cited as the Civil Rights Act of 1968. Title I. Interference with federally protected activities. Section 101. United States amends Chapter 13, Civil Rights, Title 18, United States Code, by inserting at the end thereof a new section 245 relating to federally protective civil rights activities. Nothing contained in this section shall apply to or affect activities under Title VII of this Act. I think that means 13. The revisions of this section shall not apply to acts or omissions on the part of law enforcement officers. Members of the National Guard, as defined in Section 101 of Title 10, United States Code, members of the organized militia of any state or the District of Columbia not covered by such Section 101, or members of the armed forces of the United States who are engaged in suppressing a riot or civil disturbance or restoring law and order during a riot or civil disturbance. Section 102. Amends by the analysis of Chapter 13 of Title 18 of the United States Code by adding at the end thereof an item for the catch line of Section 244 added by subsection A. Title II. Rights of Indians. Definitions. Section 201. For purposes of this title, the term Indian tribe means any tribe, band, or other group of Indians subject to the jurisdiction of the United States and recognized as possessing powers of self-government. Powers of self-government means and includes all governmental powers possessed by an Indian tribe, exclusive, legislative, and judicial, and all offices, bodies, and tribunals by and through which they are executed, including courts of Indian offenses and Indian court, means any Indian tribal court or court Indian offense. Indian rights. In general, no Indian tribe in exercising powers of self-government shall make or enforce any law prohibiting the free exercise of religion or abridging the freedom of speech or of the press of the right of the people to peaceably to assemble and petition for a redress of grievances. 2. Violate the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures, nor issue warrants, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and for the person or thing to be seized, subject any person for the same offense to be twice put in jeopardy. Compel any person in any criminal case to be a witness against himself. Take any private property for public use without just compensation. Denies any person of criminal proceeding at the right to a speedy and public trial. To be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and at his own expense to have assistance for his counsel for his defense, except as provided in subsection B. Require excessive bail, impose excessive fines, or inflict cruel and unusual punishments, except as provided in subparagraph C. Impose for conviction of any one offense and penalty for punishment greater than imprisonment for a term of 1 year, or fine of $5,000, or both. Subject to subsection B. Impose for any conviction of any one offense and any penalty or punishment greater than imprisonment for a term of 3 years, or a fine of $15,000, or both. Or and impose on a person in a criminal proceeding a total penalty or punishment greater than imprisonment for a term of 9 years. Deny any person within its jurisdiction to equal protection of its laws, or deprive any person of liberty or property without due process of law. Pass any bill or attainder or ex post facto law, or deny to any person accused of an offense punishable by imprisonment the right upon request to a trial by jury of not less than 6 persons. Offenses subject to greater than 1 year imprisonment or a fine greater than $5,000. A tribal court may subject a defendant to a term of imprisonment greater than 1 year, but not to exceed 3 years for any one offense, or a fine greater than $5,000, but not to exceed $15,000 or both. Provide to the defendant the right to effective assistance of counsel and at least equal to that guaranteed by the United States Constitution, and at the expense of tribal government to revive an indigent defendant the assistance of a defense attorney licensed to practice law by any jurisdiction in the United States that applies appropriate professional licensing standards and effectively ensures the completeness and professional responsibility of its licensed attorneys. Require that the judge presiding over the criminal proceeding has sufficient legal training to preside over criminal proceedings and is licensed to practice law for any jurisdiction in the United States. Prior to charging the defendant, make publicly available to the criminal laws, including regulations and interpretative documents, rules of evidence, and rules of criminal procedure, including rules governing the recusal of judges in appropriate circumstances of tribal government, and maintain a record of the criminal proceeding, including an audio or other recording of the trial proceeding. Sentences. In the case of a defendant sentenced in accordance with subsections B and C, a tribal court may require the defendant to serve the sentence in a tribal correctional center that has been approved by the Bureau of Indian Affairs for long-term incarceration in accordance with guidelines to be developed by the Bureau of Indian Affairs in consultation with Indian tribes not later than 180 days after the date of enactment of the Tribal Law and Order Act of 2010. In the nearest appropriate federal facility at the expense of the United States pursuant to the Bureau of Prisons Tribal Prisoner Pilot Program described in Section 304 of the Tribal Law and Order Act of 2010. In a state or local government approved detention or correctional center pursuant to an agreement between the Indian tribe and the state or local government, or an alternative rehabilitation center of an Indian tribe, or to serve another alternative form of punishment as determined by the tribal court judge pursuant to tribal law. Definition of offense. In this section, the term offense means a violation of a criminal law. Effect of section. Nothing in this section affects the obligation of the United States or any state government that has been delegated authority by the United States to investigate and prosecute any criminal violation in Indian country. Habeas corpus. The privilege of the writ habeas corpus shall be available to any person in a court of the United States to test the legality of his detention by order of an Indian tribe. Section 204-25 U.S.C. 1304 Tribal jurisdiction over crimes domestic violence. Definitions. In this section, dating violence. The term dating violence means violence committed by a person who is or has been in social relationship or romantic or intimate nature with the victim, as determined by the length of the relationship, the type relationship, and the frequency of interaction between the persons involved in the relationship. Domestic violence. The term domestic violence means violence committed by a current or former spouse or intimate partner of the victim, by a person with whom the victim shares a child in common, by a person who is cohabitating with or has cohabitated with the victim as a spouse or intimate partner, or by a person similarly situated to a spouse of the victim under the domestic or family violence laws of an Indian tribe that has jurisdiction over the Indian country where the violence occurs. Indian country. The term Indian country has the meaning given the term in Section 1151 of Title 18 the United States Code. Participating tribe. The term participating tribe means an Indian tribe that elects to exercise special domestic violence criminal jurisdiction over the Indian country of that Indian tribe. Protection order. The term protection order means any injunction, restraining order, or other order issued by a civil or criminal court for the purpose of preventing violent or threatening acts of harassment against sexual violence against contract or communication with or physical proximity to another person, and includes any temporary or final order issued by a civil or criminal court, whether obtained by filing an independent action or as a pendant-like order in another proceeding, if the civil or criminal order was issued in response to a complaint, petition, or motion filed by or on behalf of a person seeking protection. Special Domestic Violence Criminal Jurisdiction. The term Special Domestic Violence Criminal Jurisdiction means the criminal jurisdiction that a participating tribe may exercise under this section but could not otherwise exercise. Spouse or intimate partner. The term spouse or intimate partner has the meaning given the term in Section 2266 of Title 18 United States Code. Nature in the criminal jurisdiction. In general, notwithstanding any other provision of law, in addition to all powers of self-government recognized and affirmed by Section 201 and 203 of the powers of self-government and of a participating tribe, including the inherent power of that tribe, which is hereby recognized and affirmed to exercise special domestic violence criminal jurisdiction over all persons. Concurrent jurisdiction. The exercise of special domestic violence criminal jurisdiction by a participating tribe shall be concurrent with the jurisdiction of the United States, of a state, or of both. Applicability. Nothing in this section creates or eliminates any federal, state, or criminal jurisdiction over any country or affects the authority of the United States or any state government that has been delegated authority by the United States to investigate and prosecute a criminal violation in the Indian country. Exceptions. Victim and defendant are both non-Indians. In general, a participating tribe may not exercise special domestic violence criminal jurisdiction over alleged offense if neither the defendant nor the alleged victim is an Indian. Definition of victim. In this subparagraph, and with respect to a criminal proceeding in which participating tribe exercises special domestic violence criminal jurisdiction based on violation of a protection order, the term victim means a person specifically protected by a protection order that the defendant allegedly violated. Defendant lacks ties to the Indian tribe. A participating tribe may exercise special domestic violence criminal jurisdiction over a defendant only if the defendant resides in the Indian country of the participating tribe, is employed in the Indian country of the participating tribe, or if it is a spouse, intimate partner, or dating partner of a member of the participating tribe or an Indian who resides in the Indian country of the participating tribe. Criminal conduct. A participating tribe may exercise special domestic violence criminal jurisdiction over a defendant for criminal conduct that falls into one or more of the following categories. Domestic and dating violence. An act of domestic violence or dating violence that occurs in the Indian country of the participating tribe. Violations of protection orders. An act that occurs in the Indian country of the participating tribe and violates the portion of a protection order that prohibits or provides protection against violent or threatening acts or harassment against sexual violence against contact or communication with or physical proximity to another person, was issued against the defendant, is enforceable by the participating tribe, and is consistent with Section 2265B of Title 18 United States Code. Rights of defendants. In a criminal proceeding in which a participating tribe exercises special domestic violence criminal jurisdiction, the participating tribe shall provide to the defendant all applicable rights under this act. If a term of imprisonment of any length may be imposed, all rights described in Section 202, the right to a trial by impartial jury that is drawn from sources that reflect a fair cross-section of the community, and all other rights whose protection is necessary under the Constitution of the United States in order for Congress to reorganize and affirm the inherent power of the participating tribe to exercise special domestic violence criminal jurisdiction over the defendant. Petitions to stay definition. In general, a person who has filed a petition for a writ of habeas corpus in a court of the United States under Section 203 may petition that court to stay further definition of that person by the participating tribe. Grant of stay. A court shall grant a stay described in paragraph 1 if the court finds that there is a substantial likelihood that the habeas corpus petition will be granted, and after giving each alleged victim in the matter an opportunity to be heard, finds by clear and convincing evidence that under conditions imposed by the court, the petitioner is not likely to flee or pose a danger to any person or the community released. Notice, an Indian tribe that has ordered the detention of any person has a duty to timely notify such person of his rights and privileges under this subsection and under section 203. Grants the tribal governments. The Attorney General may award grants to the governments of Indian tribes or to authorize the designees of those governments to strengthen tribal criminal justice systems, to assist Indian tribes in exercising special domestic violence criminal jurisdiction, including law enforcement, including the capacity of law enforcement or court personnel to enter information onto and obtain information from national crime information databases. Grants to tribal governments. The Attorney General may award grants to the governments of Indian tribes or to authorize designees of those governments to strengthen tribal criminal justice systems, to assist Indian tribes in exercising special domestic violence criminal jurisdiction, including a. law enforcement, including the capacity of law enforcement or court personnel to enter information into and obtain information from national crime information databases. B. Prosecution. C. Trial and appellate courts. D. Prohibition systems. E. Detention and correctional facilities. F. Alternative rehabilitation centers. G. Culturally appropriate services and assistance for victims and their families. And H. Criminal codes and rules of criminal procedure, appellate procedure, and evidence. 2. To revive indigent criminal defendants with the effective assistance of licensed defense counsel at no cost to the defendant in criminal proceedings in which a participating tribe prosecutes a crime or domestic violence or dating violence or a criminal violation of protection order. To ensure that in criminal proceedings in which a participating tribe exercises special domestic violence criminal jurisdiction, jurors are summoned, selected, and instructed in a manner consistent with all applicable requirements, and to accord victims of domestic violence, dating violence, and violation of protection orders rights that are similar to the rights of a crime victim described in the section 3771A of Title 18 of the United States Code, consistent with Tribal Law and Custom Supplement, not supplement. Amounts made available under this section shall supplement and not supplement any other federal, state, tribal, or local government amounts made available to carry out activities described in this section. Authorization of appropriations. There are authorized to be appropriated $5 million for each of fiscal years through 2014 through 2018 to carry out subsection F and to provide training, technical assistance, data collection, and evaluation of the criminal justice systems of participating tribes. Title 3. Model Code Governing Codes of Indian Offenses. Section 301. The Secretary of the Interior is authorized and directed to recommend to the Congress on or before July 1, 1968, a model code to govern the administration of justice by courts in Indian offenses on Indian reservations. Such code shall include provisions which will ensure that any individual being tried for an offense by a court of Indian officers shall have the same rights, privileges, and immunities under the United States Constitution as would be guaranteed any citizen of the United States being tried in a federal court for any similar offense. Assure that any Indian individual being tried for an offense by a court of Indian offenses will be advised and made aware of his rights under the United States Constitution and under any tribal constitution applicable to such individual. Establish proper qualifications for the office of judge of the Court of Indian Offenses, and provide for the establishment of educational classes for the training of judges of courts of Indian offenses. In carrying out provisions of this title, the Secretary of the Interior shall consult with the Indian tribes, and interested agencies of the United States. There is hereby authorized to be reported such sum as may be necessary to carry out the provisions of this title. Title 5. Jurisdiction over criminal and civil actions. Section 401. Assumption by state of criminal jurisdiction. Consent of the United States. In general, the consent of the United States is hereby given to any state not having jurisdiction over criminal offenses committed by or against Indians in such areas of Indian country situated within such state to assume, with the consent of the Indian tribe occupying the particular Indian country or part thereof, which could be affected by such assumption, such measure of jurisdiction over any or all such offences committed within such Indian country or any part thereof, as it may be determined such state to the exact same extent that such state has jurisdiction over any such offence committed elsewhere within the state, and the criminal laws of such state shall have the same force and effect within such Indian country or part thereof as they have elsewhere within that state. Concurrent jurisdiction. At the request of an Indian tribe, and after consultation with and consent by the Attorney General, the United States shall accept concurrent jurisdiction to prosecute violations of sections 1152 and 1153 of the Title 18 United States Code within the Indian country of the Indian tribe. Nothing in this section shall authorize or the alienation or encumbrance or taxation of any real or personal property, including water rights belonging to any Indian or any Indian tribe, band, or community that is held in trust by the United States or is subject to a restriction against an alienation imposed by the United States, or shall authorize regulation of the use of such property in a manner inconsistent with any federal treaty, agreement, or statute, or with any regulation made pursuant thereof, or shall deprive any Indian or Indian tribe, band, or community of any right, privilege, or immunity afforded under federal treaty, agreement, or statute with respect to hunting, trapping, or fishing, or the control, licensing, or regulation thereof. Assumption by state of civil jurisdiction. Section 402. The consent of the United States is hereby given to any state not having jurisdiction over civil causes of action between Indians or to which Indians are parties which arise in the areas of Indian country situated within such state to assume, with the consent of the tribe occupying the particular Indian country or part thereof, which will be effective by such assumption, such measure of jurisdiction over any or all such civil issues of action arising within such Indian country or any part thereof, as may be determined by such state to the same exact extent that such state has jurisdiction over other civil causes of action, and those civil laws of such state that are of general application to private persons of private property shall have the same force and effect within such Indian country or part thereof they have elsewhere within that state. Nothing in this section shall authorize the alienation, encumbrance, or taxation of any real personal property, including water rights, belonging to an Indian or Indian tribe, band, or community that is held in trust by the United States or is subject to a restriction against alienation imposed by the United States, or shall authorize regulation of the use of such property in a manner inconsistent with the federal treaty, agreement, or statute, or any regulation made pursuant thereof, or shall confer jurisdiction upon the state to adjudicate in probate proceedings or otherwise the ownership or right to possession of such property or any interest therein. Any tribal ordinance or custom therefore or hereafter adopted by an Indian tribe, band, or community in the exercise of any authority which it may possess of the state, if not inconsistent with any applicable civil law of the state, will be given full force and effect in the determination of civil causes of action pursuant to this section. Reconstruction of jurisdiction by state. Section 4.3. The United States is authorized to accept a recorrection by any state of all or any measure of this criminal or civil jurisdiction or both, acquired by such state pursuant to the provisions of Section 1162 of Title 18 of the United States Code, Section 1360 of Title 28 of the United States Code, or Section 7 of the Act of August 15, 1953, 67 Statute 588, as it is in effect prior to this repeal by subsection B of this section. Consent to amend state laws. Section 404. Notwithstanding the provisions of any enabling act for the admission of a state, the consent of the United States is hereby given to the people of any state to amend, where necessary, their state constitution for existing statutes, as the case may be, to remove any legal impediment to the assumption of civil or criminal jurisdiction in accordance with the provisions of this title. The provisions of this title shall not become effective with respect to such assumption of jurisdiction by any such state until the people there have appropriately amended their state constitution or statutes as the case may be. Special election. Section 406. State jurisdiction acquired pursuant to this title with respect to criminal offenses or civil causes of action, or with respect to both, shall be applicable in Indian country only to where they are enrolled Indians within the effective area of such Indian country, except such jurisdiction by a majority vote of the adult Indians voting at a special election held for that purpose. The Secretary of the Interior shall call such a special election under such rules and regulations as he may prescribe, when requested to do so by the tribal council or other governing body, or by 20 centime of such enrolled adults. Title 5. Offenses within Indian country. Section 501. Title 6. Employment of legal counsel. Approval. Notwithstanding any other provision of law, if any application made by Indian tribe, Indian council, or any band of group of Indians, under any law requiring the approval of the Secretary of the Interior or the Commissioner of Indian Affairs of contracts or agreements relating to the employment of legal counsel, including the choice of counsel and the fixing of fees by any such Indian tribe, council, band, or group, is neither granted nor denied within 90 days following the making of such application, such approval shall be deemed to have been granted. Title 8. Materials relating to constitutional rights of Indians. Secretary to Inferior to prepare. Secretary of Inferior to prepare. Section 701. In order that the constitutional rights of Indians might be fully protected, the Secretary of the Interior is authorized and directed to have the document entitled Indian Affairs, Laws and Treaties, Senate Document Number 319, Volumes 1 and 2, 58 Congress, revised and extended to include all treaties, laws, executive orders, and regulations relating to Indian affairs in force on September 1, 1967, and to have such revised document printed at the Government Printing Office. Have revised and republished the treaties entitled Federal Indian Law, and have prepared to the extent determined by the Secretary of the Interior to be feasible, an accurate compiling of the federal opinions, published and unpublished, of the Solicitor of the Department of the Interior relating to Indian affairs, rendered by the Solicitor prior to September 1, 1967, and to have such compiling printed as a government publication at the Government Printing Office. With respect to the document entitled Indian Affairs, Laws and Treaties, as revised and extended in accordance with paragraph 1 of subsection A, and the compiling prepared in accordance with paragraph 3 of such subsection, the Secretary of the Interior shall take such action as it may be necessary to keep such document and compiling current on an annual basis. There is authorized to be appropriated for carrying out the provisions of this title such sum as it may be necessary. 13. Fair Housing. Short title. Section 800. This title may be cited as the Fair Housing Act. Policy. It is a policy of the United States to provide with unconstitutional limitations for fair housing throughout the United States. Definitions. As used in this title. Secretary means Secretary of Housing and Urban Development. Dwelling means any building, structure, or portion thereof which is occupied as, or designed or intended for occupancy as, residence by one or more families. Any vacant land which is offered for sale or lease for the construction of or creation thereon of any such building, structure, or portion thereof. Family includes a single individual. Person includes one or more individuals, corporations, partnerships, associations, labor organizations, legal representatives, mutual or companies, joint stock companies, trusts, unincorporated organizations, trustees in cases under Title 11 of the United States Code, receivers, and fiduciaries. To rent includes a lease or sublease, and let and otherwise grant for a consideration the right to occupy premises not owned by the occupant. Discriminating housing practice means an act that is unlawful under Section 804, 805, 806, or 818. State means any of the several states, the District of Columbia, the Commonwealth of Puerto Rico, or any of the territories and possessions of the United States. Handicap means, with respect to a person, a physical or mental impairment with substantial limits one or more of such person's major life activities, a record of having such an impairment, or being regarded to having such an impairment, but such term does not include current illegal use or addiction to a controlled substance as defined in Section 102 of the Controlled Substances Act, 21 U.S.C. 802. Aggrieved person includes any person who claims to have been injured by a discriminatory housing practice or believes that such person will be injured by a discriminatory housing practice that is about to occur. Complaint means the person, including the secretary, who files a complaint under Section 810. Familial status means one or more individuals who have not attained the age of 18 years being domiciled with a parent or another person having legal custody of such individual or individuals, or the designee of such parent or other person having such custody with the written permission of such parent or the other person. The protections afforded against discrimination on the basis of familial status shall apply to any person who is pregnant or is in the process of securing legal custody of any individual who has not attained the age of 18 years. Conciliation means the attempted resolution of issues raised by a complaint or the investigation of such complaint through informal negotiations involving the aggrieved person, the respondent, and the secretary. Conciliation agreement means a written agreement settling forth the resolution of the issues in a conciliation. Respondent means the person of any entity accused of a complaint, unfair housing practice, and any other person or entity identified in the course of investigation and notified as required with respect to respondents so identified under Section 810. Prevailing party has the same meaning as such terms has in Section 722 of the Revised Statutes of the United States. Section 42 UHC 1988. Alright, I'm going to leave it off here. I'll leave a link to this document down in the description below. It's very important. You guys should check it out. Along with our email, you can email us at themoney's@gmail.com for private consultation. And I'll see you guys in the next video. Have a nice day.